Senator Cruz would be next, but he's not here, so I call on Senator Kennedy.
Thank you, Mr. Chairman. Ms. Bondi, welcome. Congratulations. Can we agree that legitimacy is important to America's criminal justice system?
Yes, Senator.
Can we agree that legitimacy is important to the Department of Justice, which in part administers our criminal justice system?
Yes, Senator.
And if Americans come to believe that our criminal justice system or our Department of Justice is acting illegitimately, that makes Americans less likely to accept the results of that system, does it not?
Yes, Senator.
And that makes Americans less likely to follow the substantive laws that we pass that are administered by the Department of Justice. Isn't that true?
Yes, Senator.
And if that happens, we have chaos, don't we?
Chaos.
And the social contract is breached, isn't it?
Yes.
Do you remember a person by the name of Michael Avenatti?
Yes.
Several years ago, he was a media star here in Washington.
An attorney, correct?
Yes. He was a media star. And many members of our media loved him because he persistently bashed Donald Trump. And he was on TV every day. He was on CNN more than Wolf Blitzer. Do you know where Mr. Avenatti is today?
I believe he's sitting in prison, Senator.
He's in jail because he was a crook. And the Department of Justice helped put him there, didn't it?
Yes, Senator.
Do you remember a gentleman by the name of Sam Bankman-Fried?
Yes, Senator.
Boy genius. So smart and so powerful that he thought he could command the tides. So smart and so powerful and so rich that he would go to meetings with serious people like Bill Clinton, like Tony Blair, looking like a slob, looking like a fourth runner-up to a John Belushi lookalike contest. And he thought it was cute. Where's Mr. Bankman-Fried today?
I believe he is in prison, and I believe that's from the Netflix series I saw as well.
Mm-hmm. Because he's a crook. And who helped put him there?
The Department of Justice, Senator.
Can we agree that there's some really, really good men and women at the Department of Justice?
Many, many great men and women in the Justice Department, as well, Senator, as all the law enforcement agencies that fall within the Department of Justice. They're out there risking their lives, especially the law enforcement officers, every single day.
Can we agree, though, that there have been and may be today some bad people at the Department of Justice?
Yes, Senator.
We don't know for sure because for the last 4 years, the curtains there have been tightly drawn. But I think a minority of people there have delegitimized America's criminal justice system. The most destabilizing act that I saw in the past 4 years, maybe in the history of the department, is when Attorney General Garland decided on the basis of dubious facts and untested legal theories to criminally prosecute a former president of the United States. And not only that, this is the special part. He decided to do it after the former president of the United States had announced that he was going to run against Attorney General Garland's boss, didn't he?
Senator, are you referring to going after a political opponent?
I think so. Now, this is one person's opinion. That kind of stupid takes a plan. And I say that because, number one, this is America. That had never happened before in America. That's the sort of thing that happens in a country whose Powerball jackpot is 287 chickens and a goat. It doesn't happen here. And I call it stupid because it broke the seal. It broke the seal. It normalized it. There are a lot of ambitious prosecutors in America, Democrat and Republican. And I'll bet you right now there's some prosecutor in a particular state thinking about, well, maybe I ought to file criminal charges against President Biden's inner circle for conspiring to conceal his mental decline. And that's the road we're headed down. And you've got to fix it, Counselor. You've got to fix it. And here's, in my judgment, what I would ask you to do. Find out who the bad guys are and the bad women and get rid of them. Find out who the good people are and lift them up. But do it on the basis of facts and evidence and fairness. Because the temptation of some people is going to be, they're going to tell you, look, two wrongs don't make a right, but they do make it even. Don't resist that temptation. Help us restore legitimacy to the Department of Justice.
Thank you, Senator.
Senator Kennedy.
Thank you, Mr. Chairman. Mr. Vogt, welcome.
Thank you, Senator.
In my judgment, I do not know a single person in Washington or outside Washington who knows more about the federal budget than you do. I used to read your suggestions during President Trump's first term, many of which Congress ignored. We shouldn't have. I am delighted that the president picked you. I have read that since 2019, the population of America has increased 2%, and our spending has increased 55%. Under President Biden, I wish him well. If we had discovered life on Mars, he would have sent it money. Is that sustainable?
Senator, it's totally unsustainable, and the problem is that you go on these trajectories that we are currently on, and you don't know when you're going to get to the point of which you have some major problems as an economy, as a country, and we know that historically.
I hope you'll start with the low-hanging fruit. There's a lot. When When we sent out stimulus checks to save our economy, $1.6 billion went to dead people. And the checks were cashed, obviously fraud. OMB has estimated that in fiscal year 2023, we sent out $1.3 billion of checks to dead people, which were cashed, obviously fraud. When you die in America, your name is sent to the Social Security Administration. As you know, you become part of the master death file. Senator Carper and I discovered that Social Security would not share that information with any other department of government. So we passed a bill saying you have to share it with Treasury and other people who write checks, so we'll stop paying dead people. Duh. We got pushback, believe it or not, on the bill. We had to agree to a trial period, and that trial period ends in 2026. Will you help us make that program permanent so we can stop paying dead people?
Yes, Senator.
Now, you've served in Washington for years. You're going to be challenging the status quo. You're going to be called crazy. Many people also called Noah crazy. And then the rains came. And all the fact checkers died. You have to persevere. Now, I'm not asking you to get ahead of President Trump. But if you were king for a day, tell me how you would save money in the federal budget without impacting the American people.
Thank you, Senator. I think it's the strategy that we had in the first term, which is to go really and take a very close look at the agencies that are spending and wasting money, and I believe weaponized at times against the American people. When they put a 77-year-old Navy veteran in jail, Joe Robertson, for 18 months for building 4 ponds on his ranch to be prepared for wildfires, that's the EPA. I think we have to look at that, and we have to look at the agencies that Congress has a vote on every single year through the appropriations process. And then I think we need to go after the mandatory programs that Senator Cornyn mentioned that are keeping people out of the workforce because they have become not just a social safety net, but they have become a benefit hammock, and increasingly so in the aftermath of COVID, as many of these policies were impacting people's decisions to go back into the workforce. And I believe, and because we produced budgets along these lines, you can get sizable levels of savings and reforms that can lead to a balanced budget and get us back headed in a fiscal trajectory, not only that we would all be proud of, but we could say, this is going to keep us from fiscal ruin.
My time's expired. Ella Porter, do you have anything you'd like to add? Okay. Now's your shot. Thank you, Mr. Vogt, for your time.
Thank you.
Congratulations.
Good call there, young lady.
Take a 30-minute recess at the conclusion of Senator Kennedy's questioning.
Thank you, Mr. Chairman. I just want to say for the record that Chairman Grassley is the greatest chairman God ever put breath in. And would somebody please tell Grassley I said that? You've made a lot of people mad, haven't you, Mr. Patel?
Seems so, Senator.
You think maybe you've made the right people mad?
As my FBI agents, the BRIC agents told me when I was running cases with them across this country and around the world, if you're not ticking off some people, you're not doing your job right.
My colleague and friend Senator Durbin called you a conspiracy theorist. You remember that?
I do, Senator.
You were instrumental in revealing that the Trump-Russia election collusion hoax was a hoax, weren't you?
Yes, sir. I was a lead investigator.
Sounds to me like we need to get some new conspiracy theories because all the old ones turned out to be true.
Facts matter, Senator.
Yeah. I mean, conspiracy theorists are up something like 37-0. You're not saying that everybody at the FBI is bad, are you?
Never said that. I've overwhelmingly said multiple times that 98% of the FBI is courageous, apolitical warriors of justice. They just need better leadership, especially those who participated in these conspiracies that actually turned out to degrade them.
Who put away the Unabomber?
The FBI.
Yep. Who put away Timothy McVeigh and his Stalin's stomach for blood?
Brick agents at the FBI.
Who helped investigate Jussie Smollett, who, in an effort of self-aggrandizement, set back the fight for minority rights for years?
I think that was local authorities.
It was the FBI that opened an investigation, wasn't it?
Eventually, yes, Senator.
There have been or were some bad people at the FBI and the Justice Department, which work hand in glove, weren't there?
Unfortunately, yes, Senator.
Secretary Clinton's lawyer, a gentleman by the name of Michael Sussman, had a pass to come and go at the FBI building as he wished. Don't you think the American people have a right to know about the details of that?
Not just that, but what a political party was doing with the secure compartmented information facility with direct access to the Federal Bureau of Investigation.
Mr. Hunter Biden cheated on his income taxes. Didn't pay $1.4 million in income taxes over 4 years. And he filed fraudulent returns. He tried to deduct his hookers as a business expense, for God's sakes. And they hit him with 2 misdemeanors before there was a public outcry. Don't you think the American people are entitled to know the details of that?
The American people are entitled to a singular form of justice and the details to every public corruption investigation.
You remember Peter Strzok?
I sure do.
One of the lead investigators for Mr. Mueller's Russian collusion hoax?
Yes, Senator.
Do you remember when the Inspector General, not his colleagues, turned him in? Inspector General found that Mr. Peter Strzok said, quote, sent an email to his girlfriend, quote, just went to a Southern Virginia Walmart. I could smell the Trump support, end quote. Remember that?
He did that while employed at the FBI while working on that investigation.
Do you remember when the IG revealed another email by Mr. Strzok to his girlfriend? Mr. Strzok said, quote, I am riled up. Trump is a fucking idiot, is unable to provide a coherent answer, end of quote. You remember that?
Peter Strzok said that.
You remember when his girlfriend texted Mr. Strzok, quote, Trump's not ever going to become president, right? And Mr. Strzok replied, no, he won't. We'll stop it.
I do remember their insurance policy.
And then Mr. Strzok testified in front of God and country that never had his political beliefs impacted his work. You believe in the tooth fairy?
When I was a kid.
You believe Jimmy Hoffa died of natural causes?
He's also not in the end zone of Giant Stadium.
And then Mr. Strzok got fired, and next thing we know, the FBI and the Department of Justice, after he sued, gave him $1.2 million. Don't you think the American people are entitled to know the details of that?
Absolutely.
Now, I want you to think hard before you answer my next question. Do you believe in the adage that 2 wrongs don't make a right, but they do make it even?
Senator, I think if anyone commits a wrong in government service, the American public deserve to know the absolute secular detail of that corrupt activity.
When reforming the FBI and the Justice Department, two wrongs don't make a right, but they do make it even, is the wrong approach, isn't it?
That's correct.
And we're going to hold you accountable for that.
I hope you do.
Now, there's some good people at the FBI.
Lots.
And there have been and may still be some bad people there. And you've got to find out who the bad people are and get rid of them in accordance with due process and the rule of law. And then you've got to lift up the good people. Don't go over there and burn that place down. Go over there and make it better. Do you commit to us today that you will do that?
I commit to you, if confirmed, Senator, every single day, 24/7, 365, the FBI will be the premier law enforcement agency in the world.
Thank you, Mr. Chairman.
We'll now recess.
The flow of fentanyl. Senator Kennedy.
Dr. Farfan, the president of Mexico until 2024 was President Lopez Obrador. Is that right? And he ran for president with respect to the cartels on the slogan, hugs, not bullets. Is that right?
Well, no, he did not run on his campaign
Yes, he
with that
did.
slogan.
Yes, he did. Now, his hand-picked successor is President Steinbaum. Is that correct?
Sheinbaum.
Is that correct?
Gloria Sheinbaum.
Right. Am I right?
Yes.
Okay. I love the people of Mexico, and the people of Mexico are good friends. But isn't a big part of the problem that President Lopez Obrador and now President Sheinbaum, thank you for correcting me, by the way, live in the right front pocket of the Mexican drug cartels?
I disagree with that statement.
I thought you might. You want more task forces. Dr. Westlake, this represents 400 grams of fentanyl. Kill every person in Providence, Rhode Island. If you're a dealer and you get caught with this, you get 10 years minimum. This represents 40 grams of fentanyl. Would kill every single man, woman, and child in Culpeper, Virginia. If you get caught with this amount, as a dealer, you get a 5-year minimum sentence. This is where it gets special. This represents 10 grams of PCP. If you get caught with it, as a dealer, you get 5 years minimum. Is fentanyl more dangerous than PCP?
Yeah, absolutely, Senator. The fentanyl is classified, can be classified as a lethal weapon. I did a chart on it. And
this is 5 grams of meth. That's what this represents. If you're a dealer and you get caught with it, your minimum sentence is 5 years. Is fentanyl, you get caught with this much fentanyl, 5 years or 10 years. Get caught with this much fentanyl, 5 years. Get caught with this much meth, you can hardly see it, you get 5 years. Does that make any sense to you?
No, sir.
It's like cell deep stupid, isn't it? You don't need a task force. to see the logic of that. I've got a bill, it's called the Fairness in Fentanyl Sentencing, I've reintroduced. This bill will lower the 5-year mandatory minimum for 40 grams of fentanyl to 2 grams of fentanyl. It'll lower the 10-year mandatory minimum from 400 grams of fentanyl to 20 grams of fentanyl. This bill won't punish addicts. It'll help. It's not going to help until President Lopez Obrador and President Scheinbaum get out of the pockets of the drug cartels. But it's a start. This bill will punish dealers. Thank you, Madam Chairman.
Senator Whitehouse.
Thank you, Madam Chair. Welcome to all the witnesses.
Kennedy,
Governor Bowman.
the floor is yours.
Thank you, Mr. Chairman.
You're welcome.
You're a fine American.
Thank you.
You still have to pay your taxes, though.
I do.
On May 1st now because
I
of
understand.
Hurricane Helene.
I got an
Thank you.
extension on mine.
I'm very excited about that. I'll extend to you 30 seconds for this
Thank you.
colloquy.
Governor Bowman, briefly, if you will, because we've got to go vote. What's the Basel III endgame?
It's an international agreement of different countries that participate in the Basel Accords.
What's its objective?
To ensure that there's parity across jurisdictions for financial regulation and a level playing field.
It calls for more regulation of American banks, doesn't it?
In some cases, it does, yes.
Your predecessor, Mr. Barr, loved Basel III endgame like the devil loves sin, didn't he?
He embraced it in his proposal.
Mm-hmm. He bear hugged it. He French kissed it. What problem are we trying to solve with Basel III endgame?
The original proposal was intended
No,
to increase
Mr.
capital.
Barr's proposal.
Right.
What problem are we trying to solve? We have stress tests right now for banks, right?
That's absolutely correct.
And we have capital standards, right?
We do.
What's broken about it?
I think we'll need to take a fresh look at the last Basel agreement and determine what's appropriate for U.S. banks and their ability to have a level playing field across around the world.
Well, let me put it another way. Washington has this propensity, when something's not broken, is to take it apart and loosen a few screws so that it will be. Now, if there's some problem that we're trying to solve with adopting these international standards, I'd like to know it. I asked that repeatedly of Mr. Barr, and he never could. I mean, he was and is. I like him very much, very smart. He's also a silver-tongued devil. He could talk a dog off a meat wagon. And he never answered that question. And so it seems to me that what the Board of Governors has to do is come back and tell us what's broken. Let me ask Mr. Fogel, what's the International Monetary Fund? Briefly, if you don't mind.
Senator, to be honest, I know what it is, but it actually isn't related to the job I've been nominated for, which is global markets at Commerce. It probably better handled by Treasury Department.
All right, that's fair. I understand a dodge when I see it. You did that pretty artfully. How about you, Mr. Hurley? I bet you know.
Yes, sir. I do know what the IMF is, and the
briefly, if you don't mind.
Well, so again, it would be my colleague who will get.
You own the IMF. You know. I'm hoping you're not telling me you don't know what the IMF. If you're going to be in charge of terrorism and financial crimes.
So yes, sir. I'm very familiar with the IMF. It won't be, I'll have sanctions at TFI and be working with law.
The IMF loans money to other countries, right? Who puts up most of the money for the IMF?
The United States, sir.
That's right. There are about 190 countries in it, and by far we put up most, right?
Yes, sir.
What are special drawing rights?
I'm not terribly familiar with special drawing rights.
You need to get familiar.
Yes, sir.
Special drawing right is when the IMF gets together and decides to declare a dividend to all of the countries. And it's like a dividend. It's really a sheet of paper that says any country can take these dividends, a sheet of paper, and go redeem it for the currency of any other country. And Secretary Yellen did that. To the tune of $650 billion. And she dodged congressional approval by coming for an amount just below the trigger for us to approve it. We gave money to Iran, to Russia, to China, and we're putting up the money. Why aren't we doing that?
Are you asking me, sir?
Yes, sir.
Yeah. I completely agree, sir.
Well, I've got a bill to say that whenever the Treasury catches a wild hare and decides they want to give away American taxpayer money to Iran, as Treasury Yellen did, that she has to come to Congress for approval. You'll support that, won't you?
I look forward to looking at the legislation, sir. Yes, sir.
Thank you, Mr. Chairman.
Being a legal answer, it depends.
On what?
On the nature and circumstances of the case before us.
So there are certain circumstances that would cause you to recommend to the administration that it defy a lower court order.
Well, Senator, for example, in some circumstances, in order for a court order to be challenged, an official must be held in contempt. And so, yes, it is possible that we could get there. However, I would be remiss were we to go down the path of talking about hypotheticals because, as I say, I can never imagine a situation in which I would be asked to give that advice.
Chairman, thank you for your generosity with my time. I appreciate it. Thank you all.
Senator Kennedy.
Thank you, Mr. Chairman. Gentlemen, I don't want to spend a lot of time on this, but I also don't want to debate how many lawyers can dance on the head of a pin. I think you understand where a lot of these questions are coming from. Mr. Geiser, would you ever advise a client to ignore a federal district court opinion?
Thank you very much, Senator Kennedy. I would advise it.
Thank me. You can thank me by answering it.
I would advise a client on how best to comply with all lawful court orders.
Is that a yes or a no?
Yes, sir.
You would advise a client not to follow a federal district court opinion?
I would advise a client to follow court orders.
Would you ever advise a client not to follow a federal court of appeals decision?
I had the privilege of clerking on 2 federal courts of appeals.
Is that a yes or no?
Yes. I would advise them to follow the orders of courts of appeals.
How about Supreme Court opinion?
Yes, Senator, I would advise them to follow the Supreme Court's orders, as President Trump has been very clear that those orders are to be followed.
Mr. Woodward, let me ask you the same question. Would you ever advise a client not to follow a district court opinion?
No, Senator.
Would you ever advise a client not to abide by an opinion of the Federal Court of Appeals?
No, Senator. Again, it's difficult to answer in the hypothetical, but...
Would you ever advise a client not to follow an opinion by the United States Supreme Court?
No, Senator. As the President has been clear, he will follow all orders of the United States Supreme Court.
Tell me what I would need to do under the APA, the Administrative Procedures Act, if I want to change a current rule.
Well, Senator, as a senator, you would pass a law that would change the...
No. I don't want to play games here, Counsel. What would one have to do? What would the head of an agency have to do to overturn a current rule or regulation?
Well, Senator, I apologize. I know that there are many ways to do that, and I don't want to play games either. I want to answer the question.
That's fair.
There are many ways in which an agency can overturn a rule.
Well, you have to give notice, right?
As a general matter, yes, Senator.
Yeah. And you have to invite input, right?
As a general matter, yes, Senator.
Okay. And sometimes you have to hold a hearing, right?
Sometimes you do, Senator.
Yeah. Are there any exceptions to that under the Administrative Procedures Act?
Under the Administrative Procedures Act, I'm not aware of any exceptions, but there are exceptions under the law.
Okay. Are you familiar with the good cause exception to the Administrative Procedures Act?
Senator, I am vaguely familiar with that exception.
Okay. Do you know what it says?
No, Senator, I do not.
I understand. Here's what I'm driving at. Are you familiar with the Supreme Court's case called Loper-Bright?
Senator, I am vaguely familiar with the Supreme Court's decision in Loper-Bright.
They overturned Chevron doctrine, right?
The Chevron deference doctrine, yes, Senator.
Okay. If there is a rule promulgated by a prior administration or even by a current administration that is in clear violation of the United States Supreme Court's pronouncement under Loper-Bright, ruling unconstitutional the Chevron doctrine, would it be possible, strike that, would it be prudent for the Justice Department to exercise authority under the good cause exception to the APA in the public interest and forego the rule, the notice and comment?
So, Senator, thank you. I think I now understand your question. And that is I was alluding to the non-APA process. I mean, if a rule has been promulgated that is plainly unconstitutional, it absolutely would be appropriate for the Department of Justice to look at that rule and make a determination.
My point is, you don't have to ignore the APA to do that, do you?
I would say it depends, but I take your point.
I mean, the APA provides an exception.
Yes, Senator.
It's section 553. It's right there, big as Dallas. Am I done?
Yeah.
I thought that was maybe a mouse or something.
Senator Cool.
Thank you, Chairman Grassley, Ranking Member Durbin.
Professor, tell me about the Loper-Bright case.
Sure. So Loper-Bright is the case that overruled the Chevron doctrine. And the Chevron doctrine originally required that if there is an agency statute that governs an agency's conduct, the agency gets deference, meaning a thumb on the scale, when it's interpreting what that statute might mean as it's carrying out its duties. Loper-Bright determined that that framework was inconsistent with the Administrative Procedures Act, and instead that moving forward, courts should decide all of those statutory interpretation cases as a de novo matter, meaning the agency doesn't get any sort of special head start.
How much deference did a federal court have to give to an administrative agency under the Chevron doctrine?
Sure. So the court would originally make a step one determination about whether the statute was ambiguous or not. That's in the eye of the beholder sometimes. But if the court determined that the statute was ambiguous in the relevant sense, meaning it didn't resolve the question the agency was facing, it would defer to the agency's view of the meaning so long as the agency's interpretation was well explained and reasonable.
What's the relationship, if any, between Loper-Bright and West Virginia v. EPA?
So that's a fascinating question. I think, West Virginia versus EPA applied Chevron, but said we're less likely to find ambiguity, and indeed Congress needs to speak clearly if the agency is purporting to resolve a matter of, in the court's terms, political or social significance. And following Loper-Bright, of course, there is no deference. And I think some have commented, including Justice Barrett, that the best way to think about West Virginia versus EPA in interpreting statutes is that it informs the context of how we understand what the statutory terms mean in the context of an agency delegation. So the fact that the agency is purporting to carry out its duties might resolve whether or not the particular question is sufficiently clearly delegated by Congress.
That just seems to me like a distinction without a difference. I mean, doesn't Loper-Bright wipe out the need for West Virginia v. EPA? Why do we still need a major questions doctrine?
So it's certainly true that West Virginia versus EPA, I think, was partially driven by non-delegation doctrine concerns and concerns about deferring to agencies when doing so threatened our separation of powers. After Chevron has been overruled, of course, that might be relevant in a smaller number of cases, but I do think that the major questions doctrine still has vitality in understanding the best meaning of the statute as Loper-Bright now requires.
What's the public rights doctrine?
So most recently, the public rights doctrine has been applied in the Seventh Amendment context, and the Supreme Court has a decision named Jarkissi, where there's a line of precedent saying that if a matter involves public rights, so the conferral of a public benefit, for example, that might be the type of matter that Congress can vest adjudication of in Article I tribunal or in an administrative agency.
What's a public right?
That's a very difficult question to answer in many cases.
That's why I'm asking you.
Yeah, so I think the best way to think about it is to contrast it with private rights. And what the Supreme Court has instructed with respect to private rights is that they're what we would think of as common law type claims. So contracts, property, torts, the stuff of Westminster in the court's terms. And so if you have a matter like that, that's the type of matter that needs to go before a jury to ensure that the Seventh Amendment's jury protections are abided. By contrast, if there's an internal administrative process, Social Security benefits, things like that, that looks more like a public right that wouldn't have existed but for the government granting it.
And what did the Supreme Court hold in, was it Jarkissi?
That's right.
What did the Supreme Court hold?
So the Supreme Court there held that certain matters of the Securities and Exchange Commission actually looked more like common law fraud claims and more like property-based claims that must be tried to a jury in court and cannot be vested in the in-house SEC proceedings to be tried before an administrative tribunal.
My time is done. Thank you, Professor.
Okay, against my condition to be nice to all of these folks. So with that, Senator Kennedy.
I'm always nice. How many of you worked for Senator Schmidt? All four of you. Is it true that he was suspended 23 times in junior high school in February alone? Look, I'm not trying to trick you. I'm not going to ask you how you rule on cases, and I'm not going to ask you about your political beliefs. I just want to know how you think. Let's start with the counselor on the end. Let's suppose I'm a cop, and I'm on duty, and it's 3 o'clock in the morning, and I see somebody driving down the road, not many other people around. It's on a Saturday night. Can I stop him?
Just because you see him driving around?
Yeah.
There would need to be more of a basis than that.
So the answer is no.
Correct.
Okay. Let's suppose that I recognize him. And on 3 previous occasions, he's been caught for charged with DWI. But he's not driving erratically. I'm the cop again, can I stop him constitutionally?
Same answer. No.
No?
You would need more than that to be able to conduct an
Why
investigative
don't
stop.
why doesn't that give me reasonable suspicion?
I think merely the fact that he was driving at 3 a.m. and had been pulled over previously for driving under the influence wouldn't be enough. Now, it certainly, if he were swerving or driving improperly in some other way, if he committed a traffic violation or something along those lines, certainly the officer would be well within his rights.
So we can agree our privacy is precious to us, even if we're in a car, right?
I would agree that the Fourth Amendment very thankfully protects us all from unreasonable searches and seizures.
So how come the cops can set up a roadblock and stop everybody when they don't have either reasonable suspicion or probable cause, just to check and see if they have insurance?
So there are limitations on scenarios like that, roadblock
But
cases.
can they do it first, counsel? I mean,
officers can set up roadblocks if they are applying it based on a neutral and articulable standard, and if that standard relates to something that is specific to automobiles. So they could not stop every car to search.
you're right about the law, but why is that not, they don't have reasonable suspicion. They're stopping everybody. They certainly don't have probable cause. It's intrusive. I mean, I can spend 10 minutes in line for them to check my insurance. What's the basis for that being constitutional?
I think the way I would frame it is that the courts have decided that scenarios like that, and in scenarios like that, officers would not be acting unreasonably. So they would not be violating somebody's Fourth Amendment rights.
Because the Fourth Amendment
guarantees against
prohibits unreasonable searches and seizures.
Correct.
And how do you determine whether something's unreasonable or not?
Well, I think that would very much depend on the situation, the specific facts and the context.
Don't you balance the costs and benefits?
In a scenario like that, yes.
Okay, cool. Judge, what's the rule now that the Supreme Court follows on reapportionment cases? Congressional redistricting.
Congressional redistricting. My understanding, Senator, is that the Supreme Court has decided that that's a political issue, and under the political issue doctrine that essentially the courts really don't have much of anything to say about political redistricting.
If Missouri's legislature gets together and it redraws districts, and they're, let's say, a majority of Democrats in the legislature, so they say, we're going to redraw these districts to benefit Democrats. And we're not going to be reluctant to say so. They say it in front of God and country. Is that okay?
Well, it's pursuant to the Supreme Court precedent. It's legal.
Yeah. Okay. All right. I'm not going to get to all of you. Counselor? Just counselor. Yes, ma'am. Do you think the meaning of the Constitution is immutable?
So I think that the U.S. Supreme Court has said that
I want to know what you think.
So, yeah, my view in terms of like what it is that, you know, my way of looking at the Constitution is to say, what does the text say, and what did it mean at the time that it was passed? And this is something that the U.S. Supreme Court also says. If that's not clear, I think there are other things you can look to, like history and tradition, to decide what the
You
text
look
means.
to what it meant at the time it was passed?
Correct.
What it meant to whom?
To the people who were passing it.
To the people who wrote it?
So I think there are various different ways of looking at this, and I think the U.S. Supreme Court has said that you look at the meaning that the words would have to the public at the time that the Constitution was ratified.
That's right. I'm done. Thank you. Congratulations.
Senator Padilla.
Thank you, Mr. Chair, and appreciate your patience in allowing me to.
Thank you, Mr. Chairman. Mr. Beauvais, I'm looking at your resume. It's Beauvais, right?
Beauvais, Senator, like with a
Beauvais,
long
I
E.
apologize, sir.
No worries, thank you.
Mr. Bovee, you spent a lot of time at the Justice Department. I look here. You were a paralegal there for 2 years in the early 2000s. You served from 2012 to 2021. How many times have you seen a Justice Department employee act on the basis of his or her, act predominantly on the basis of his or her political beliefs as opposed to the law?
Senator, I would say that as a prosecutor in my time at SDNY, I'm not sure that I did see that. It should be and it must be.
Have you seen it other than as a prosecutor?
I believe that I have.
When?
During my representation of President Trump.
What'd you see?
I witnessed members of the special counsel's office taking positions about the need to go to trial quickly before the election, the amount of time that President Trump would be allotted to review discovery and prepare motions, that I've found in my experience to be completely inconsistent with normal practice, which led me to draw inferences of the nature that you're suggesting, Senator.
Counselor, you sent a memo directing one of your underlings, I don't mean that in a pejorative sense, but somebody under you in the hierarchy, directing that the prosecution against Mayor Adams be dismissed. Is that right?
Yes, Senator.
Okay. Who made that decision to dismiss the charges?
I think that's set forth in the memo that I participated in the decision with the authorization of the Attorney General of the United States.
Okay, so the Attorney General of the United States made the call.
She was a part of the decision, yes, Senator.
Who else was involved?
Beyond what's in the public record on that matter, I'm not able to get into the internal deliberations on that, Senator.
Okay, but there were others involved
Yes.
at the department?
Yes.
Anywhere else?
No.
Okay. You're under oath. Why did you folks dismiss the charges against Mayor Adams?
For the reasons set forth in the motion that you're referencing, there were two concerns, Senator. One was based on the weaponization of the criminal justice system, and that concern was substantiated.
What do you mean weaponization of the political justice system?
Abuse.
I know that, but I mean, can you be more specific?
In this particular case,
Do you think the charges were brought against Mayor Adams for political reasons?
again, I'm just right now drawing on what we said publicly in the briefs, and I signed those briefs because I believe in the arguments that were made. I believe that irrespective of what happened at the outset of that case, what the former U.S. attorney did to promote the ongoing prosecution at a time when there was at least an appearance that he had his own personal political objectives resulted in the weaponization of that particular criminal justice process.
So you dismissed it because of the weaponization. Any other reason?
Yes, there was a second independent basis set forth in the motion, and that was concerns about the effect of the ongoing prosecution on Mayor Adams' ability to govern and protect the public in New York City, and also to campaign in the ongoing mayoral election.
Okay. Do you believe in a higher being?
It's a very personal question, Senator, but I do.
I want you to look me in the eye and swear to your higher being when you answer this question. Did you make a deal, a political deal, to dismiss the charges against Mayor Adams?
Absolutely not.
Did anybody else that you witnessed make a political deal to dismiss the charges?
Absolutely not.
You swear to your higher being?
I swear to my higher being and on every bone in my body.
Thank you, Mr. Chairman.
Senator Klobuchar.
Thank you, Mr. Chairman. Mr. Bove, I was just listening to Senator Kennedy to kick us off.
Thank you, Madam Chair. Judge Dudek, did I say that name right?
That's correct, Senator.
All right, what's the warrant requirement?
Well, before the court would issue a warrant, you have to assess to make sure that there's probable cause to either search the place.
When's a warrant required?
Excuse me?
When is a warrant required?
The general rule is a warrant is required anytime that the government wants to search a person, place, or thing.
Could you speak into the mic?
Oh, I'm sorry, Senator. Yeah, I said the backdrop rule is that a warrant is required anytime the government wants to search a person, place, or a thing.
And to arrest you, right?
There are some exceptions to that, but generally, yes.
Okay. And there are exceptions to the warrant requirement for searching and arresting people, are they not? Are there not?
Yes, Senator, there are.
Okay. Suppose the Florida Supreme Court ruled that here in Florida, we're not going to recognize any exceptions to the warrant requirement. You have to have a warrant to search someone, and you have to have a warrant to arrest someone. Mm-hmm. No exceptions. Can the Florida Supreme Court do that?
Well, Senator, under the Supremacy Clause, they'd be bound by what the Fourth Amendment dictates. Of course, they're free to make their own requirements as it.
What if the Florida Supreme Court did it under the Florida Constitution and not the federal Constitution?
Well, they would still, Senator, have to apply with what the federal Constitution said.
No, they wouldn't.
Under the Supremacy Clause.
Do you know what adequate and independent state grounds means?
Sure. Of course, I would understand that they could have independent and adequate state grounds for state law, but they.
No, they don't. As long as you don't take away rights, but add to them, a state can do whatever it wants to under its state constitution, can it?
Yes, sir. Yes,
but
Senator.
That's not what you just said. You think the Supremacy Clause applies? The Supremacy Clause applies.
Well,
you want to change your answer?
Senator, I would like to change my answer to the extent that I agree with you that the Florida legislature or Florida could do exactly what you said. I meant in my statement is that.
Trust me, it can. Judge Pruitt, I'm sorry, I can't see that far.
It's Judge Pratt, Senator. Yes.
Judge Pratt, I apologize. I can't see that far. Can a state legislature pass a law that discriminates against a group of people over another group of people for inferior treatment?
Well, Senator, the federal Constitution and the state Constitution both contain protections against various forms of discrimination.
But can a state legislature say we're going to treat this group of people differently than another group of people?
So I think, Senator, an example where a legislature
could. Tell me first
if
a state can do that.
Yes, a state can, for example, require a driving age which discriminates on the basis of age. To say, for example,
when can a state legislature not do that?
When it's seeking to do so under a basis that is protected under the state or federal Constitution.
Okay, good. Judge, tell me about the privileges and immunities clause.
The Privileges and Immunities Clause, there's a privileges and immunities and a privileges or immunities clause. There's one of each. One of them relates.
Privileges and is what I'm asking you about.
I believe you're referring to what came through in one of the Reconstruction amendments and discussing the fact that that the privileges and immunities of citizenship would be extended under those.
First, what article is it in?
I believe it's in the 13th Amendment.
No, fourth. Article 4. What does it do?
Senator, you have pinpointed a question that in my 9 years as a judge, in my decade of private practice before this, my 2 years as a law clerk, my 2 years on law review in law school, including a year as editor-in-chief, didn't ever come up.
You tell me you don't know?
So it's an interesting question.
Yes,
and
ma'am. I know it's interesting. That's why I asked it.
Yes.
But you don't know the answer. Just tell me. I got a lot of ground to cover here.
I would be very happy to research it.
Okay. Do you know what the privileges or immunities clause is?
With respect to my answer would be the same on that.
You don't know it either.
Well, with respect to the privileges and immunities of citizenship, my recollection is that
privileges are immunities.
Yes, my recollection is that was discussed in one of the Reconstruction amendments.
Which one do you know?
I believe it was the 13th or the 14th.
Okay. All right, Judge. What's Title VI of the Civil Rights Act of '64 do? Ma'am?
Which judge?
This judge down here on the far end.
Artau?
I can't see that far.
Just making sure, because there's 4 judges there. Judge Artau, I'm going to let you answer that briefly.
Hey, I want to reclaim my time, Mr. Chairman.
You can
Madam
answer
Chairman.
that briefly.
Judge, what's Title VI of the Civil Rights Act do?
I believe that ensures that people are treated equally in any places that they would be, that they would not be discriminated against.
In all cases?
Refresh my recollection as to what you were referring to,
I'm
Senator.
referring to Title VI of the Civil Rights Act of 1964, which you're going to see every other Thursday as a federal judge.
So I believe that's under the Commerce Clause. They wanted to make sure that there was not any discrimination going on with regard to race, and that was addressing
it. It prohibits discriminating on the basis of race or color or national origin. Under what circumstance? Do you know the answer?
Under any circumstances where you're providing services to people?
No, it's only if you're getting federal money. You need to brush up on that one. I'm way over my time. Thank you, Madam Chair.
Thank you, Senator Kennedy. Senator Kennedy, to kick us off.
Thank you, Madam Chair. Judge Dudick, did I say that name right?
That's correct, Senator.
All right, what's the warrant requirement?
Well, before the court would issue a warrant, you have to assess to make sure that there's probable cause to either search the place.
When's a warrant required?
Excuse me?
When is a warrant required?
The general rule is a warrant is required anytime that the government wants to search a person, place, or thing.
Could you speak into the mic?
Oh, I'm sorry, Senator. Yeah, I said the backdrop rule is that a warrant is required anytime the government wants to search a person, place, or a thing.
And to arrest you, right?
There are some exceptions to that, but generally, yes.
Okay. And there are exceptions to the warrant requirement for searching and arresting people, are they not? Are there not?
Yes, Senator, there are.
Okay. Suppose the Florida Supreme Court ruled that here in Florida, we're not going to recognize any exceptions to the warrant requirement. You have to have a warrant to search someone, and you have to have a warrant to arrest someone. Mm-hmm. No exceptions. Can the Florida Supreme Court do that?
Well, Senator, under the Supremacy Clause, they'd be bound by what the Fourth Amendment dictates. Of course, they're free to make their own requirements as it.
What if the Florida Supreme Court did it under the Florida Constitution and not the federal Constitution?
Well, they would still, Senator, have to apply with what the federal Constitution said.
No, they wouldn't.
Under the Supremacy Clause.
Do you know what adequate and independent state grounds means?
Sure. Of course, I would understand that they could have independent and adequate state grounds for state law, but they
No, they don't. As long as you don't take away rights, but add to them, a state can do whatever it wants to under its state constitution, can it?
Yes, sir. Yes,
But that's
Senator.
not what you just said. You think the supremacy clause applies? The supremacy clause applies.
Well,
You want to change your answer?
Senator, I would like to change my answer to the extent that I agree with you that the Florida legislature or Florida could do exactly what you said. I meant in my statement is that.
Trust me, it can. Judge Pruitt, I'm sorry, I can't see that far.
It's Judge Pratt, Senator. Yes.
Judge Pratt, I apologize, I can't see that far. Can a state legislature pass a law that discriminates against a group of people over another group of people for inferior treatment?
Well, Senator, the federal Constitution and the state Constitution both contain protections against various forms of discrimination.
But can a state legislature say this group, we're going to treat this group of people differently than another group of people?
So I think, Senator, an example where a legislature
Tell
could
me first if a state can do that.
Yes, a state can, for example, require a driving age which discriminates on the basis of age. To say, for example,
When can a state? Congratulations, gentlemen. Mr. Tong, you were asked about some of the things you said back in college. And one of the things that you were asked about was a statement you made in 2004. I believe that women are simply better than men at some things. Did you say that?
I did say that, Your Senator.
You said that you believe that women are better at some things, right?
That's right, Senator.
You didn't say women are worse at some things, did you?
I did not say that, Senator.
Just want to be sure I understand. How is that denigrating women?
It was not denigrating women, and I did not intend it to be so, Senator.
Yeah. I mean, you said they're better at some things. If you said they were worse at some things, you would be denigrating women, wouldn't you?
I would, Senator.
I don't know if I asked you this, but you didn't say they could do things worse. You said better, right? Just want to be sure I understand.
That's right, Senator.
Does government have free speech rights?
Government does have free speech rights.
How so? The First Amendment doesn't mention government, except to the extent that government, it is there to protect, for government, for us to have protection against government restricting our speech. How can government have free speech?
Senator, you are right to the extent that the First Amendment refers to Congress. Congress shall not make any law abridging the freedom of speech or of the press. But there is a government speech doctrine that allows the government to convey a political message it wishes to, and the government is not committed to a policy of neutrality at all times.
Have you ever been to Boston?
I have been to Boston.
Okay. You seen the Boston City Hall?
I believe I have, Senator.
There's a plaza in front, and there's some flagpoles. And Boston, when different groups are having protests or demonstrations or rallies on the plaza, allows those groups to fly their flag. Someone wanted to fly a Christian flag, and the city of Boston said no. And the Supreme Court and the city of Boston said, that's our choice. That's government speech. We don't want to fly a Christian flag. So how come the Supreme Court said that they had to fly the Christian flag if government has free speech.
Senator, if the government opens up its plaza to all comers, so to speak, then it's restricted under the public forum doctrine in terms of what viewpoints it would decide to favor or not.
That's not necessarily so, is it, Counselor? I mean, let's suppose Texas, this actually happened. Someone in Texas lets people buy specialty license plates. You know, I love little warm puppies and stuff like that. You can buy a specialty license plate. And somebody wanted to have a specialty license plate that pictured the Confederate flag. And Texas said no. And the Supreme Court said Texas doesn't have to do it, government speech. So isn't that inconsistent with what you just said?
Senator, it is not inconsistent. This area of law is extremely complicated when something qualifies as a public forum such that viewpoint discrimination might not be allowed versus a public benefit and public conditions that the government can rightly impose on others, on its recipients. Then that shades into government speech, in which case the government would have more control over what kind of speech gets projected into the public square. But there is potential for tension there between the two doctrines that you raised, Senator.
The chairman's going to gavel me to shut up in a second. I just want to be sure I understand. Back at Yale, you said there are some things that women are better at, right?
Yes, Senator.
Not worse.
That's right.
Better.
Yes, Senator.
Okay. Thank you, Mr. Chairman.
Senator Whitehouse.
May I have permission to enter into the record 2 articles from Louisville papers, one the Courier Journal and one from the Louisville News?
Without objection.
Thank you.
Mr. Meredith, you worked for Governor Bevin.
Yes, Senator.
You were his lawyer.
I was one of the lawyers in the office, Senator.
Okay. Governor Bevin issued some controversial pardons. Is that right?
He did, Senator.
The FBI investigated those pardons, did it not?
Yes, Senator. That's right.
Did the FBI file charges against Governor Bevin?
My understanding is they did not, Senator.
Okay. Did you advise Governor Bevin on any of those controversial pardons?
The only controversial pardon that that I advised him on was one for Mr. Irvin Edge, and I recommended that Mr. Edge not be pardoned.
And was he pardoned?
My understanding from reading news articles is that he was pardoned.
Okay, so the governor didn't take your advice?
Apparently not, Senator.
Okay. But you didn't have anything to do with any of the other controversial pardons?
No, Senator.
Okay. If the New York Times, Mr. Meredith, published an editorial, let's suppose it said, Senator Kennedy is a bad senator. We don't like him. We think he's an ignorant slut. And I called the New York Times, and I said, okay, I want to write a letter to the editor replying. Can the New York Times tell me no?
I believe that they could tell you no, Senator.
Well, what if I said, if they told me no, I said, okay, I want to buy a full-page ad that says John Kennedy's a good senator. He is not an ignorant slut. And they said no. Can they do that?
I think the First Amendment would allow them to exercise editorial discretion and control over the types of ads they want to sell.
You think it's purely a First Amendment case?
There could be. I mean, I think there are potentially other laws that could govern how they make their decisions to sell ads. But I think if they're making a decision about whether you want to whether you can buy an ad that says Senator Kennedy's a good senator, I think they've, I think the First Amendment would allow them to exercise.
Suppose I'm running for re-election after this editorial, and I go to my local television station and I say, I want to run a political ad. And they say, no. The New York Times says you're an ignorant slut. We're not going to run your ad. Can they do that?
I think that's governed. That's governed by different laws pertaining to the airwaves, which are governed by federal statutes.
There's only one Constitution.
That's right.
How can a news organization deny me the right to reply to an editorial that denigrates me, but yet I have a right to run a television ad that says the New York Times is wrong?
I think as in order to have permission to use the airwaves, I think federal law requires TV stations to give equal time or equal opportunity to buy ads.
Why is that constitutional?
Well, it's constitutional because my understanding, at least, is that the federal government controls. The airwaves essentially are federal property that the federal government can regulate and authorize the use of.
Yeah, but the federal government has to abide by the First Amendment, doesn't it?
It does.
I don't know. Explain to me how the New York Times can say no to me wanting a right of reply, but a TV station can't prohibit me from replying.
Senator, my understanding of the law is that the airwaves would be a public resource that the federal government regulates.
You think they're a common carrier?
You know, I don't know the law on this specifically, Senator. I don't know that the common carrier analysis would apply there. Perhaps it would. I don't know.
Suppose I have my cell phone service with AT&T, and I call AT&T, and I say I want to expand my cell phone service, and they say nope. We read that New York Times article. You can't do it. Can AT&T turn me down?
I think theoretically they probably could.
No, how? Why? What basis?
Well, I take that back. You're right. They probably can't because it's the same thing.
Why?
They're using the airwaves as well.
They're a common carrier, right?
I think that analysis probably applies there. That's right.
Okay, Mr. Mercer, can Congress pass a law that says cities are no longer able to participate in zoning? We're going to take it over at the federal level because we don't have enough houses. Would that be constitutional?
Senator Kennedy, I don't believe it would be.
Why not?
I believe that's the sort of thing that the Constitution has, not given Congress the authority under Article 1 to do that, and in fact—
Why not? On what basis?
In our system of federalism, those things that are not set forth in the Constitution are reserved to the states, and zoning is one of those quintessential public health, safety, welfare matters that we reserve to local government to resolve. And so I don't believe it would be permissible for this body to attempt to codify something in that regard.
So local government would win in that instance?
That is my understanding.
Okay, suppose local government came back and said, not only now that we've won and we have jurisdiction over our own zoning and our own housing laws, if you want to build a new house in our city, the permit is now $50,000. Can they do that?
Senator, essentially, I think the same analysis applies. I think that the local government would have the ability to establish that, and I don't think Congress could overrule it, and I think they would have the inherent authority to do so.
Why isn't that a taking under the United States Constitution and the Fifth Amendment?
Senator, that would be a whole different analysis, but I don't believe—
Same analysis. We just established they have the right to zone as they wish, and so and to regulate local housing. They're doing it. They're saying $50,000 to get a building permit. You're telling me that's constitutional?
I believe, Senator, I believe it would be. I think that they could establish that they need, in order to engage in the permitting process and go through what they need to do as a local government. I doubt very much whether that would be a violation under a compensable taking under the Fifth Amendment.
You familiar with Sheets v. County of El Dorado?
Senator, no, I'm not. That is not something that I've encountered in my practice.
The Supreme Court struck down a $23,420 fee for a permit to build a home.
I was not familiar with that precedent, Senator. I'll make sure.
At some point, local government, which has wide discretion when exercising its police power, at some point, their actions can step over the line, can they not?
That is true, Senator. And
violate what? The takings clause?
In this case, I'm not familiar with if Sheets was based upon the Fifth Amendment or if there was some other analysis, but...
It was Fifth Amendment.
Okay.
Y'all hungry? I am.
Yes, Senator.
Okay. All right, gentlemen, thank you. Thanks to all the nominees today. Written questions for the record may be submitted until August 6th at 5 o'clock. We would ask you to respond promptly. This hearing is adjourned.
Kennedy.
Professor, congratulations. I believe you testified that you think the Constitution should be interpreted according to its original public meaning. Is that right?
Yes, Senator.
What does original public meaning mean?
Yes, Senator. So the original part of that phrase refers to the fact that when we look at interpreting a text, we want to interpret it at the time it was...
Professor, look me in the eye and just answer my question. What does original public meaning mean?
It means the meaning that the text as it was understood by the public at the time it became law.
Okay. So you think Brown v. Board of Education was incorrectly decided?
Well, Senator, I think Brown versus Board of Education was correctly decided. Scholars who have looked at the original meaning of phrases at that time and the reasoning in that case sometimes question the reasoning of the case.
How many people in the United States of America at the time the Constitution was drafted do you think supported racial integration of schools? You think that was a majority view, do you?
Well, Senator,
but first, Professor, do you think that was a majority view? Do you think most Americans at the time the Constitution was drafted supported integration of public schools, racial integration?
Well, Senator, I don't know as a sociological matter what percentage of people thought what at that time. I should point out that when we got to Brown versus Board of Education, of course, there had been several fundamental amendments to the...
But isn't that inconsistent with your statement that you have to interpret it according to original public meaning?
Well, what about the 14th Amendment and the 13th Amendment and the 15th Amendment? So original public meaning would mean with those... Well, that would mean we would interpret those amendments and those protections with the understanding of the text and structure at the time those amendments were ratified, which is different, of course, in the 19th century.
Let's go back to Brown v. Board. Look, I think Brown v. Board was correctly decided, and I suspect you do too. But if you say we interpret the Constitution according to the way that people at that time understood it, do you really think that people at that time in America supported racially integrated schools? Do you really believe that?
Well, Senator, I think at the time of the ratification of the 13th, 14th Amendment, and 15th, all which have...
But do you think people at that time originally at that time supported integrated schools.
Well, Senator, on that particular question, I don't know it as a policy matter whether they were thinking about that particular issue. I think they certainly understood that the 14th Amendment, for which a massive part of this country essentially lost lives fighting the Civil War, certainly understood it to require racial
Professor,
equality.
You're not answering my question. I'm just trying to understand how you think. It's very easy to say, we interpret the Constitution according to its original public meaning, which as I appreciate your testimony, means the way people who read the Constitution at that time interpreted it. Is that right?
Yes, Senator.
Okay. Do you think that most people at that time looked at the United States Constitution and said, well, here it is, big as Dallas, racially integrated schools are required? Do you really believe that?
Senator, I don't know, but
And if you don't, I don't think you do, because I think historically that wasn't the case. So how do you square that with the holding of Brown v. Board?
Well, I guess what I'm trying to say is I think there are several steps in between that have not come up yet in our conversation, which is that you look at the text and structure, which of the 13th, 14th, and 15th Amendments clearly is requiring racial equality. And then over time, that has to be applied to different questions as they arise in context. So if the requirement is that all races be treated equally under the law, and the evidence shows that segregated schools is not doing that, then the requirement could be applied to integrate schools.
When you interpret a statute, you talked about interpreting it according to its plain meaning. What if the statute is ambiguous?
Well, Senator, if the statute...
What do you do if it's ambiguous?
If it's ambiguous on the particular question coming before the court, I start with that phrase, but I also look at the context of surrounding provisions.
No. How ambiguous? I understand you define ambiguity as the language plus the surrounding language.
Yes.
I get that part. How ambiguous does it have to be? 51% ambiguous or just a little bit ambiguous?
So I have to say I would use the same approach essentially in all cases, regardless of the ambiguity, because I would always start with the text, move to the surrounding provisions with the aim of fully understanding what Congress and the President had enacted. And only at that point...
Professor, I'm going to run out of time. With respect, answer my question.
Well,
okay, you're giving me professor talk. How ambiguous does it have to be?
I mean, I think under the Supreme Court's recent precedent in Chevron, it underscored that the court can never just rest and say it's ambiguous. The court has to come up with an answer.
Yeah.
So
why don't you just look at legislative history?
Well, you can't look at legislative history statements one by one because the individual intent... Well, Senator, with respect, because this body has its role in our system as an institution, not one by one. So your personal understanding of the law doesn't matter.
This will be my last question. I'm sorry. Coons went way over. So you're telling me that it doesn't help you at all to go through and look at the congressional record or read the committee reports or any of that? You don't think that's helpful in interpreting what a statute means?
It depends on the way in which it's being read. If it gives helpful statutory history, if it helps to refer to other portions of context, sure, but not to give it legally binding impact in and of itself. I would always be looking at a broad range of sources and use each of these statements as just one piece of evidence about what people understood the statute to mean at the time. So no, I would never take a piece of legislative history in isolation and give it legal impact.
Thank you, Madam Chair.
Thank you.
Dr. Myron, do presidents, any president, generally appoint their enemies?
Thank you, Senator, for the question.
Don't thank me. It just takes up time.
I believe that when they nominate them,
do they generally appoint their enemies?
They don't believe they are when they're when they're making.
Do presidents, any president, generally appoint people that they agree with on social and economic policy?
I believe that presidents appoint people whose
That's
policies...
a yes, isn't it?
Yes.
Because we live in the real world, don't we?
Yes.
Are you personally responsible for everything President Trump says?
No, my role as the chairman of the
Before President Trump says something as President of the United States, does he call you up and say, Stephen, I'm about to say this and I want your approval? Does he do that?
Never.
And after the president says something, does he call you up and say, Stephen, was that okay? Are you okay with this?
Nope, I have an advisory role.
Okay. Now, sometimes intelligent adults, reasonable people disagree. Is that true?
Very often.
Is it part of your job description when you disagree with something the president says to call a press conference and say, he's wrong about this and let me explain to you why? Is that part of your job description?
Not as CH.
Is that part of the job description of any aide that you know of to President Biden?
No.
How about for President Obama?
No.
How about for President Clinton?
No.
We don't live in La La Land, do we? Do we?
No.
Now, monetary policy is important, and the Fed is in charge of it. But monetary policy is not the only thing that's important. Fiscal policy is important, isn't it?
Fiscal policy is extremely important.
And I don't care how low the Federal Reserve lowers interest rates. If the United States Congress is profligate in its spending, if it spends money like it's pond water, if it runs up $37 trillion in debt, and deficit spends to the tune of 7% every year, that also has an impact on employment and economic growth and inflation, does it not?
Absolutely, and I think people often make a mistake by looking solely at monetary policy when fiscal policy is a huge driver.
And in fact, the Federal Reserve can lower short-term rates through the Open Market Committee all you want. But that doesn't necessarily mean that long rates, 10 years and above, are going to go down, does it?
Not necessarily.
Right, because if the bond market counts too, doesn't it?
Of course.
If the bond, you can lower rates as low as you want to, but if the bond market thinks that inflation is on the horizon, those rates are going to keep going up or at least stay steady. Isn't that accurate?
Yes, the Federal Reserve does not control the long end of the yield curve.
Okay, so what Congress does matters, doesn't it?
Hugely.
My good friend Senator Warren says, you're Donald Trump's puppet. Are you Donald Trump's puppet?
Not at all. I'm very independently minded, as shown by my willingness to stray from consensus and have out-of-consensus views, and I believe that, I will continue to be as independent, in my thinking process, if confirmed.
We're going to hold you to that, Governor, future Governor. You need to call them like you see them. There's nothing wrong with politicians in Washington offering their opinions. You can't stop them. But we need a monetary plan that was put together by something other than vodka and darts. And that's what we had the Federal Reserve for. Now, you're going to get a lot of advice from politicians. I'm not saying they're always wrong. Even a blind chicken finds a mealworm now and then. But you've got to call them like you see them. And ignore, nothing wrong with people giving their advice, but ignore all the rhetoric from all politicians. Will you give me that commitment?
I do commit to that. Thank you.
Thank you, Mr. Chairman.
Thank you, Senator Durbin. Senator Kennedy.
Thank you, Madam Chair, and congratulations, gentlemen. I thought I would just start down here and then move this way, if that's okay. Judge, what is the rational basis test?
Senator, I believe the rational basis test is going to be one of your least stringent test and whether a law has a rational basis for the outcome intended or the governmental interest that you're trying to obtain.
Okay. What if the legislature or the Congress, as the case may be, doesn't list a reason? What if they just pass the statute?
Senator, I would submit that probably happens many times, and I think it's the role of the court when determining such matters as a definition. I think it's the role of the court to determine whether the usage of that statute, using its wording in plain meaning, whether the usage of that statute is going to reach the governmental interest that you hope is obvious, but sometimes you have to determine.
So you just create the basis, the reason for the statute?
I don't think that you create it, Senator, but I don't think that most statutes, to be honest, I don't think that they tell you what they are trying to accomplish so much as they say, this is the law. For example, possession of a narcotic. It's going to say it's illegal to possess this. We determine if there's a rational basis that forwards the ends of the governmental interest.
Well, how do you determine if there's a rational basis? Do you look at the statute or do you look behind the statute?
Well, I think that you always look at the statute. Now, I think you also look at any other precedent or case law that has interpreted the statute. However, you look to the language of the statute to determine what it does and what effect that might have.
Okay. Counselor, let's suppose that a legislature passes a statute that says if you have a college degree or a more advanced degree, you don't have to take a driver's license test. And let's suppose that assume for a second that the federal court has jurisdiction over a challenge to the constitutionality of that test, of that statute, rather. What test are you going to apply, Counselor?
Senator, that would be a classification that doesn't turn on any sort of protected characteristic, and so it would be a rational basis test that would apply in that instance.
You don't see any suspect classification?
No, Senator.
You don't see any fundamental right?
No, Senator.
Okay, what if the legislature didn't provide, so you would use the rational basis test?
I would, Senator.
And you would uphold that statute?
I think there could be some rational basis that a court could conceive of to justify that statute, and rational basis is not.
So you would invent the rational basis, the reason for the statute?
That's generally how the test has been applied by the Supreme Court and by lower courts, and as a district court judge, I would be bound by that Supreme Court precedent.
Okay. Judge, tell me the difference, sir, between notice pleading and fact pleading.
Notice pleading, of course, goes to your due process issues under the 14th Amendment.
Well, what's the difference between notice pleading and fact pleading? We use two systems in America, as you know.
Yes, sir. Notice pleading is based on, of course, that goes into your jurisdiction, your personal jurisdiction, and then the fact pleading, of course, goes into your subject matter jurisdiction.
What system does the federal judiciary use, notice or fact?
No, fact.
Okay. Judge, I'm about out of time. Can I have 30 more seconds, Madam Chair? You heard me talk to the nominee for the Third Circuit about how she would interpret the Constitution, and she said that the Constitution should be interpreted according to its meaning as understood by the people in America at the time the Constitution was passed. Do you agree with that?
I do, Senator.
Okay. Let me ask you what I asked her. How do you square that with Brown v. Board of Education?
I would adopt a lot of what she said, actually. I believe the 14th Amendment, as it came in, addressed.
14th Amendment was later.
It was later. It was a reconstruction.
Can you turn your microphone on, please?
Sorry
Thank
about
you.
that. I believe the Brown versus Board of Education is correctly decided.
I do too, but when my friends, and I'm a textualist as well, but when my friends say, well, we have to interpret the Constitution in accordance with the way the average American viewed the Constitution at the time. I say, okay, that seems fair to me. Do you think that the average American at that time looked at the Constitution and supported and believed that it provided for racially integrated schools? Do you think that was a majority view at the time?
Senator, all I know is that Brown versus Board of Education is good law, and it was correctly decided.
And why do you think it was correctly decided? I agree with you, but why?
Well,
if you interpret the Constitution by looking at its public meaning at the time.
Separate was not, it was inherently unequal, not equal. And
It was what?
I just don't believe that there's any appetite in this country for any type of de jure type of segregation. I believe
At the time the Constitution was passed?
I'm talking about right now. I believe that it's good
No,
law,
but
Senator.
okay. I've gone way, way over. I'm sorry, Counselor, I didn't get to you.
No problem, Senator.
Thank you, Mr. Chairman. I'm sorry, I can't see that far.
Bragdon, me?
Who wants to volunteer?
Senator, I would be happy
Let's
to
just
go
start in the
first.
middle and we'll work to the end. Tell me, Mr. Also?
Orso, yes. thank you,
Orso, I'm
Senator.
sorry. I really can't. I guess I need to get new glasses. Mr. Orso, let's suppose, imagine this situation. Small printing company, they manufacture envelopes, stationery like that sort of thing. 20 employees, small operation. They take customer orders, go in the back, print the stuff. They wear uniforms because the owner wants to promote his company with the company logo. Employee shows up one day in uniform, but she's wearing a burqa. And the owner says, you can't wear a burqa here. And the employee says, yes, I can. And the owner says, you're fired. Tell me how you'd analyze that case, what questions you need to know, who would win, who would lose, according to Supreme Court precedent.
Sure. I would likely look first to Title VII of the Civil Rights Act of 1964, since
That's
it's
correct.
an employment case.
And what's Title VII say?
It says that a person cannot be discriminated against in employment on the basis of race, color, national origin, religion,
Right.
gender. And then I would apply the facts of that case, pursuant to.
What facts would you have to know?
I'd have to know if the wearing of that burqa was indicative of any potential religious, closely, sincerely held religious belief. And then if so, would analyze it from there.
What if the employer said, my customers won't like it? Is that a justification?
I don't believe that would be sufficient justification to discriminate against someone based on religious belief. I think you'd have to take into account whether the employer is providing any type of accommodation that allows for that person to.
What if
to
the
work
small business owner said, it's dangerous? The employee might get the burqa caught in the manufacturing apparatus.
I think I would have to look at the case law if there's anything similar on that, but my instinct is that, in terms of protecting the safety of employees is a valid concern of an employer.
Okay, fair enough. David, I really
Bragdon.
can't see. I need to do
It's
something.
Mr. Bragdon. David
Mr.
Bragdon. Thank you.
Mr. Bragdon, tell me about supplemental jurisdiction.
Supplemental jurisdiction, I am having trouble remembering that term because it does not come up in criminal practice very much, but I believe it's
going to come up in
jurisdiction-
federal district court
Absolutely.
every other Thursday.
And I will certainly carefully research any issue that were to come before me if I'm
It used to be
confirmed.
called pendant jurisdiction. Does that help?
But I think it's jurisdiction that builds on jurisdiction. I'm thinking it builds on jurisdiction of another party who's already properly before the court. But I don't specifically remember, Senator Kennedy.
Okay. Do you know?
Senator, I would say that is my understanding as well, and I don't have too much to add in my years as an AUSA. I haven't been working on that recently.
Who knows the answer? What's your name?
This is Judge Rodriguez, and so I am a sitting U.S. Magistrate Judge right now, so I think that I'll step in for the panel. There was a recent Supreme Court case on this, so supplemental jurisdiction is when the court would have original jurisdiction over some sort of federal question, but then there is a state question, and so that's where the court can exercise its discretion over supplemental jurisdiction. A lot of times where that comes up is if something gets kicked, and there's only state law claims, does the court exercise jurisdiction otherwise over those state law claims? And there was a recent Supreme Court decision on this that basically said that the court could get divested of its jurisdiction if a plaintiff dismissed everything, all of the federal claims. And so it goes back to a jurisdiction issue, and that's what you would be normally looking at.
Okay. We go back to Mr. Rousseau. How do you amend the Constitution?
I think you'd look to, Senator, I think you'd look to Article 5 of the Constitution and follow the instructions for 2/3 of the legislature or 2/3 of the states.
Okay, fair enough. Let me move to the gentleman to your right. What's the difference between a preliminary and a permanent injunction, and how you decide them, Counselor?
A preliminary injunction, well, let me start with a permanent injunction would be a final judgment in the case that occurs after the completion of all the litigation.
What do you have to let's start with the preliminary. What do you have to prove to
Sure. For
the
a
judge?
preliminary injunction, there's several standards the court looks at. You're looking at irreparable harm. You're looking at the likelihood of success in the merits in the ultimate case as it goes through court. You're looking at balancing the equities of the parties. So those are some of the factors the court considers and whether to grant that. And it's essentially, the idea is, can you keep things in place while the litigation is pending?
What factors do you look at for a permanent injunction?
Well, the permanent injunction would depend on the relevant law or action that's being considered.
Yeah, but what factors do you look at for a permanent injunction?
So for a permanent injunction,
you look at the same factors, don't you?
I think that, in my mind, a permanent injunction depends on the underlying statute or relief that you're taking, and it can vary based on the kind of case.
Well, in a preliminary injunction, you're asking, is the plaintiff or the movement likely to succeed on the merits?
And
in
so,
a permanent injunction, you're asking, has the party succeeded on the merits?
Correct.
Right?
My only point is what the merits are is going to vary based on the kind of case.
Fair enough. Counselor, tell me about class actions. What are they, and what are the elements of you have to prove?
Senator, I believe you're referring to Rule 23. So in order to have a class action, you're allowing one plaintiff or just a few plaintiffs to stand in for a class of a larger number of individuals. To bring that class, you have to meet the factors that are set out, the elements that are set out in Rule 23. So we're looking at numerosity, typicality, representation, numerosity, commonality, I believe, but those are some of the factors in it.
I didn't realize I'd gone this far over. I'm sorry.
This concludes the entrance exam. Now we'll thank you, Senator Kennedy.
I really apologize. I didn't mean to go this far.
Thank you, Senator Kennedy. I appreciate you asking the question. Senator Durbin.
Thank you, Mr. Chairman. Mr. Paul Hollis, I've known him for a long time. He is a favorite son in Louisiana. He served honorably and admirably in our state legislature. He was on the board of elementary and secondary education. No more important job in my state. There's nobody in this country that knows more about coins and coinage and numismatics than Paul Hollis, and all of us in Louisiana are so proud of him. Mr. Hill, did you read the 234-page Cleary-Gottlieb report about the sexual harassment and the bullying and the touching and the sleaze and the racial discrimination at the FDIC under President Biden?
I did, Senator.
I'm going to clean up the language here because we've got kids here. Did you read the part of the report where one young female employee said that her supervisor looked her in the eye and described her as being, quote, like a grizzly bear with breasts, but he didn't use the term breast. Did you read that?
I did, yes.
Did you read the part where one FDIC supervisor asked a young female subordinate, quote, does your husband blank you?
I did, Senator.
You read that?
Yes.
Did you read the part of the report where one young female employee said her supervisor sent her a text saying, quote, get naked, blank?
Yes, Senator.
Did you read the part of the report where one female employee said that her supervisor at the FDIC, been there for years, sent her a picture of his private parts?
Yes, Senator.
Now, look, I could go on all day. And you know what I've heard back? I've talked about this for a long time. You know what I've heard back from the FDIC? Nothing. Zero. Zilch. Nada. I haven't heard from you. Last time I checked, 97 employees at your agency, if you're confirmed, reported repeated instances of sexual assault, sexual advances, and unwanted touching. 91 other employees reported repeated incidents of sex discrimination. 187 employees reported repeated incidents of bullying and threats. 191 employees reported repeated incidents of racial discrimination. Did you read the part of the report, Mr. Hill, where an Hispanic employee said that his supervisor asked him to recite the Pledge of Allegiance to, quote, prove that he was an American? Did you read that?
I did, Senator.
Did it make you proud?
It did not.
You've been there since January, right?
That's correct.
I heard you talk about transparency and accountability. Those are pretty words. I want a report within 30 days about what's been done. I want to know who's been fired. I want to know who's been prosecuted. I want to know who's been moved around with so-called demotion, taking care of their brother-in-law, and got a bonus.
We can certainly provide that for you.
Well, you better, because I'm going to tell you, I'm not sure I'm going to vote for you. I've had enough of this. I have had enough of this. And if your name came up in front of me right now, I wouldn't vote for you.
Senator,
it's got nothing to do with your policy chops, but I have had enough.
Yep.
I have had enough. This is not an isolated incident. And I've talked about this repeatedly, and I've heard nothing from you, Mr. Hill, and I've had nothing from your agency. And you know what I assume? Look, I trust everybody. I believe in the adage, trust in God, but tie up your camel.
Senator, we are fully committed to cleaning up the agency.
Yeah, well, you got 30 days or whatever I just said. I'll stick to whatever I just said to give me a report about what's happened to these people.
We will do so.
And otherwise, you can forget about my vote. Thank you, Mr. Chairman.